When a relationship breaks down and anger spikes over money or children, the immediate instinct is to issue an ultimatum. Under pressure, many people feel the only way to find a resolution is to say, "I'll see you in court." That instinct hits a logistical wall. The family court system faces severe backlogs, meaning a 4 to 6 month wait for your first appointment. Even that date is fragile, often listed at risk and canceled last minute. Meanwhile, legal fees continue to climb. A rush to the courtroom often leads into a slow, expensive administrative trap, steadily depleting the household assets you're trying to protect. To prevent every dispute from defaulting to a trial, the courts have built a structural countermeasure. Under Section 10 of the Children and Families Act 2014, the law prevents you from taking a standard family application directly to a judge. Instead, you must pass a mandatory checkpoint, the Mediation Information and Assessment Meeting, or MIAM. For almost all private family law applications involving children or finances, this meeting is a legal requirement. The justice system uses this administrative pause to ensure that parties have explored alternatives before they are allowed to use limited judicial resources. Despite common assumptions, a MIAM involves no counseling or attempts at reconciliation. It is a confidential assessment with a specially trained family mediator. They sit down with you, usually in a one-to-one setting, to determine if your specific dispute can be settled without a formal trial. This chart compares the average financial commitment for both routes. On the left, a successful mediation averages £1,641 total for both parties. On the right, the cost of a full court battle is uncapped, often reaching tens of thousands of pounds. There are practical benefits as well. Academic research indicates that agreements reached through mediation are more durable long-term and cause less emotional distress for children than orders imposed by a judge. The MIAM serves as a focused intervention, showing families that a cheaper, more stable path exists before they commit to months of litigation. Judges enforce this requirement aggressively. In the case of Re B, a child, the court issued a direct warning. Do not bring your litigation to the family court unless it is genuinely necessary. You will be criticized and sanctions may be imposed. If you file an application without a Form FM1, signed by an authorized mediator, the court staff will generally reject the papers, or a judge will adjourn your case until you attend the meeting. The law does, however, maintain a safety net for situations where a fair negotiation is impossible. You can legally bypass the MIAM if there is evidence of domestic abuse, an immediate risk to life or safety, if a party is bankrupt, or if social services are already involved due to child welfare concerns. This balance ensures the system can push for cooperation while providing immediate protection for the most vulnerable. If the mediator determines your case isn't suitable for negotiation, they sign the Form FM1. This makes you legally eligible to file your application and bring the matter before a judge. If both parties agree to proceed, you enter formal mediation. Here, you work with the mediator to shape your own legally binding agreements over your finances and children. The system now operates on the principle that the courtroom is often the least effective place to reorganize a household. Forcing a pause through a MIAM reflects the statistical reality that negotiated settlements are more durable than judicial orders. Handing the decision to a judge means giving up your agency. You are letting a stranger dictate the terms of your future finances and how you interact with your children. The MIAM is an attempt to hand that power back to separating families. It offers a chance to retain control and build your own future before the state builds it for you.